Put down your vapes, put down your pens, set aside your bag of edibles. We're going to go old school today and talk about drinking and some of the perils and some of the consequences that can befall people when they serve minors at house parties, or if people are overserved at bars or restaurants as paying customers. So the first thing I want to address is while I know things like pens and vapes and marijuana is much more in vogue these days, and there's actually been some reports I've read that alcohol use amongst younger people is actually down considerably. It's still something that requires attention, and it's still something that my practice comes across with some regularity. So the first thing we'll talk about is what's generally referred to as the social host law. It's codified in the General Obligations Law of the State of New York, Section 11-100, and that specifically concerns people under the age of 21 being provided alcohol at places like at house parties or maybe even, say, college parties, fraternity parties, etc. It's important to note that there doesn't have to be a sale of alcohol to people under the age of 21 for this law to apply. It actually involves the provision of alcohol to anyone under the age of 21. Now, there's some other sections of law that create the legal framework that serve as the basis for these types of violations. We don't need to get into all those technicalities, but for anyone who's interested, alcohol beverage law, Section 65 is something that would kind of be referred to in these instances, but none of that really changes the bottom line of what I'm going to be discussing now. When someone is served and they shouldn't have been served, they're underage, and that underage drunk kid will just say, to keep this discussion easy, hurt somebody, what happens? Obviously, the victim of that drunk kid has a claim. Sometimes it could be a drunk driver. That happens with unfortunate regularity. But I've actually had a couple cases where drunk driving wasn't implicated. It was more an assault that took place. And I can think of two examples. One goes back a number of years and one is a little more recent. In both cases, I represented a person. They were under the ages of 21, both of them, and they were at various parties. The first one involved a typical blowout style college party when the host parents were, I believe, out of the country at the time. So the parents really had no idea what was happening, or at least that's what the evidence bore out. And my client, unfortunately, got smashed in the face with a ceramic beer mug and had extensive bleeding. He had to be rushed to a hospital to have emergency surgery to stop the bleeding. And unfortunately, he was left with a very bad scar on his face. That case was intensely litigated, and the primary defendants were the hosts of the party. They were just young people themselves. It was a brother and a sister, I believe, and their parents, who were the homeowners. The testimony revealed that mom and dad had no idea what was going on. They were out of the country. They certainly didn't give their blessing to their children to have a raging, out-of-control party. Nonetheless, the party really did get out of hand. In fact, I remember that there was testimony that, I don't know if it was online or through text messaging, but word was getting out around town that there was a raging party and a lot of people just ended up crashing the party. And in fact, the assailant in that case was one of those party crashers. He was definitely drunk based on the testimony that was elicited. And I don't remember what exactly led to him hitting my client in the face with a mug, but it was nothing justified. It was essentially, from what I remember, an unprovoked attack, and he was badly hurt. His only recourse in reality was to sue the homeowners and the party host. Naturally, the assailant who hit him really didn't have much to his name. He was indeed prosecuted, and I believe he may have actually been incarcerated for a short period of time. But that doesn't do a heck of a lot to help my clients with their medical bills and future medical expenses, which was definitely something of a consideration for my client in that particular case. That case ended up settling. I do know my clients were a little less than thrilled with the result because the injury was so extensive and the amount of money coming from the insurance company for the host and the homeowners was less than they had hoped for. However, there were some serious evidence problems we encountered in that case. We had some serious challenges. And the primary challenge was proving that the host of the party knowingly provided the alcohol to the assailant that made him drunk. There was some conflicting information about how intoxicated he may have been upon arrival. So that was something that was a concern. But nonetheless, a recovery was made, and it wasn't insignificant by any means. But it was something that I remember that clients were certainly hoping for more. A second, more recent example involved some just craziness at a poker night, of all things. The assailant's family in that regard was hosting a rather elaborate poker night. Turns out that they employed their son, who was underage, to serve as a bartender. The son, in that instance, had friends, including my client at the time, and some other young men who were there, and they were drinking. This went on for some time, didn't turn into the raging party that first example had, but there were some unfortunate fisticuffs that unfolded, and my client really was essentially sucker punched and jumped by the poker father's son, his former friend. The injuries were also very serious in that case as well. That one did not require extensive litigation because we had a lot of names and a lot of eyewitness testimony showing that, yes, there was definitely underage drinking going on at this poker night. It was a rather elaborate poker night. It was more than just the home game. There was a couple different tables. There were a number of adults there. There were a number of people there. And we were able to show that essentially that the assailant was helping himself to all the alcohol that his father and mother had made available for the poker group. So there, though, social host law was rather easily implicated, and there was some police involvement pretty quickly. So that one did not have to go quite the length and the distance that the first one did. But those are just two examples of how an injury victim in these circumstances can find their way to a financial recovery when alcohol involving minors is involved. They're not always the easiest cases, though. I don't want there to be any, misinterpretation about the success that we had in these instances. They are not always that easy. Sometimes the drinking driver cases can lend themselves to a more clear set of facts because you have things like breathalyzer tests administered and maybe even blood test results that are basically commanded or warranted by the police or judge if necessary. So those can be a little clearer to prove, but nonetheless, proving that the provision of alcohol sometimes is a little more challenging than you might first think, especially when you have young men or women who've been visiting a number of places prior to the incident that gives rise to an injury like my clients had experienced.